could follow up on that. The 83 cases we found, essentially by making phone calls, which is finding people through public records, all of them reported that after their case was settled, that no one from the federal government ever came to contact them or ask how their child was doing. And this is one of the reasons why we feel that we need to look at this population and ask, what does vaccine injury look like for these people? What are the nature of the injuries? And this is a population that's readily available for the federal government to study, but not be prohibitively expensive. But in that issue of leaving no stone unturned and fully disclosing, should not the Department of Justice have disclosed the fact that previous cases of autism have in fact been compensated?
Well, I mean, that goes to the whole nature of the program. And as Professor Myers said, Peter and I teach a course together at GW with all the students. And by the end of the year, if you could have them come in and talk to you, they would tell you what's wrong with the program. After spending a year working the program, they can come in and tell you exactly what's wrong with it. We go back to all our previous classes and bring a whole group together to describe the problems of the program. But it is a problem with the program that has become very adversarial. I don't think it was ever intended for this program that the lawyers should be fighting against each other, or that the special masters should be opinionated and not trying to help petitioners. I mean, special masters, some of the recent ones who have been appointed to the program, they're not the same special masters we had in the early days. In the early days of the program, we had some wonderful, compassionate special masters who were very good at listening to cases. They didn't rule for everybody, but they gave petitioners the benefit of the doubt. Today we have some special masters who, quite frankly, look for ways to rule against petitioners. I once said to one of the special masters, you seem to spend so much time trying to figure out how far you can go in ruling against petitioners before the Court of Appeals overturns you. Why don't you see how far you can go in ruling in favor of petitioners before the Court of Appeals overturns you? Why this bias? It doesn't make sense.
I have a question for you. As a lawyer practicing in the vaccine program, I know we've spent a substantial part of the time today talking about autism, but it's my understanding that obviously the majority of the cases that are being filed in the program today are adults that are also being injured by vaccines. And practicing in that area as you do, there seems to be a discrepancy, that there's no consistency within the rulings as you would find in normal court system, where we have precedents and judges follow the rules of other judges. Within the special masters, as well as the claims court judges, and to a certain extent the Federal Circuit, isn't it accurate to say that special masters are not bound by each other's decisions? Claims court judges are not bound by each other's decisions. And even looking at, which is mentioned in Professor Myers' article, 2 cases that came up at the same time to the Federal Circuit within a year of each other with nearly exact same facts, the Andrew case and the Moberly case, received opposite rulings from the Federal Circuit. And that my question is, without congressional guidance on clarification of burden of proof, clarification of the intent of the program, and things like that, do you see this complete uncertainty for petitioners, as well as anyone looking in, as to what's compensable and what's not compensable? Flu shots for adults, for instance, getting GBS, we know that the government doesn't concede those cases, but will frequently settle those cases, and yet there's nothing available to the public to indicate that. Do you see that continuing unless Congress steps in and clarifies?
For those of you who don't know, this is my partner, Renee Jeffrey, and that was a leading question.
Yes. You can object later, but for now, answer it, please.
I think what Renee was trying to tell me was that I did really address some of the other important issues in the program, one being that there is no binding precedent program. So if one special master rules in favor of a case, rules that flu vaccine can cause GBS, for instance, that doesn't bind other special masters. So there's no binding authority. So every time you have that case, you have to just keep retrying it over and over again. I mean, it would be nice if every time we won a case, it would create a table injury, so we wouldn't have to reinvent the wheel and go back there every time. That doesn't happen. On the other hand, what does happen, is like happened with the test cases that have been talked about, is if some petitioner loses a case, then that is always held against me. Even though I may not have been a party to that case, I didn't have the opportunity to cross-examine witnesses or be involved in that case. I sometimes wish that our test case had gone to trial instead of being settled, because it would have been much nicer to have a judgment and to actually win the case rather than to have a concession. So, but they're not binding, and they're not binding in the court. The two cases that you referred to in the Court of Appeals, we won an appeal called Andrew, and on the very same facts, the Moberly case with a different panel of judges in the Court of Appeals was lost. So even all the way up to that level, you're getting disparate rulings. And it's very frustrating to have to keep relitigating over and over and over again. And, you know, we try to get better at litigating, but obviously the government brings in more and more people and more experts, raises more and more issues. The flavor of the month now recently has been trying to disprove the diagnosis. Say, well, you know, that really isn't what you're calling. Or then the other flavor of the month is to say, oh, well, the onset must have been earlier. Or genetics, they would have been that way anyway, regardless of what happened. So we're fighting constant battles, biological, complicated medical battles all the time. These are very complicated, difficult, highly adversarial cases, and they shouldn't be. There's certainly enough evidence for a special master to rule in favor of an autistic case. We've had it happen many times. The difficulty comes with, in autism at least, with the more insidious onsets. When you have a slower, insidious onset, it's hard to relate it to a defined event like a vaccine. And that's the problem we have without having good epidemiology or some biological marker or test. Really, the only biological marker we've ever had in the program was for when we used to give the live polio vaccine. Because up until they stopped using the live polio vaccine, we'd only have 5 or 6 cases of polio a year, and they were all caused by the live polio vaccine. And they were actually able to identify the virus and figure out that it was the actual virus in the vaccine as opposed to a wild polio virus. So those are the only cases we've ever had in the program where there's really some biological marker. I mean, it'd be wonderful if God would come down and put a dot in the forehead every time it's a vaccine injury. We could distinguish that, but we can't. And that's why that burden of proof is important. Because when you can't put the dot in the head, you want to err on the side of compensating these children. What's the worst thing that can happen with the lower burden of proof? Some child gets compensation? That's so terrible? Of course it's not terrible. Otherwise, what are they on Medicaid? So we're going to pay for it anyway. We're paying for autism in this country. The epidemic is going to be paid for. It's going to become very expensive as these kids get older, become more violent, become more aggressive, get into trouble, or have to find housing situations. It's going to be a disaster. And we're going to have to find a way to pay for it. And if the program has failed them, then we're going to have a problem with confidence in the program. Yes, ma'am.